Good afternoon, everybody. Welcome to another HSB employment law webinar. Happy to be back with everybody. I feel like it's been a little while since I have done one of these, and so it's nice to see everybody virtually. Looks like we've gotten some good participation today. We're going to do sort of a mid-year check-in with a little bit of a hodgepodge of topics. So hopefully we can hit on some things that maybe some of you have been seeing and thinking about. But a couple of reminders before we get started. I think most of you are pretty familiar with Haynsworth at this point in time, although I think we do have a few new people today. One of the things that we do on the employment law team at HSB is we run the SC Employers blog, which is a good way to hear about future webinars and events, as well as to keep up with updates that happen throughout the year, recent developments in employment law and things like that. So go check that out, subscribe to that if you're not already. We will not inundate your inbox every day or anything like that. It's very manageable. We try to send out a post every 2 weeks or so. Feel free to use the chat or the Q&A, either feature on the Zoom platform. I see somebody sending a message in there right now. I'm used to seeing the message come across as I present, so it will not bother me in the least bit. Don't have to wait until the end. I will, at the end ask for questions or comments, but, feel free to, while you're thinking about them, go ahead and enter those into the chat, and I'll either address them as they come up if I see them, or wait until the very end and address them. But no, we're going to be kind of hitting on a number of things today in sort of general terms, and we're not going to be getting too much into the weeds on any one topic. So definitely ask questions on specifics if you have them, or if there's something that you wanted to ask about that I had not planned to talk about. That's completely fine too. We're going to be sending the slides to you, and the course has been submitted for credit. And just a disclaimer that this is not intended to be specific legal advice for any particular situation that you may have, but is more general information for everyone's knowledge. So with that, we'll dive right into it, and you'll see a little roadmap here for our discussion today, what we're going to talk about, just so you have an idea of where we're going. I'm going to give just a little update at the top on some of my thoughts about where we are in the labor economy, and then bounce around with some legal trends that I'm seeing and some hot topics, and then talk about potential legislation. I had originally planned to talk today mostly as sort of a legislative update, because the General Assembly in South Carolina just finished its session. And as I was doing the presentation, I realized that there was not quite as much to talk about with legislation, mostly because of what did not happen, then, could fill up an hour-long presentation. And so I've dialed back a little bit the discussion on legislation, but we will still talk about that, as well as talk about some of these other issues as well. So just off the top, I kind of wanted to talk for a couple of minutes about where we are in the economy, and what I'm hearing from clients and reading about and seeing anecdotally as well. Obviously, it's an interesting economy. It's the stock market has taken a massive crash or market correction, however you see it, which has got everybody a little bit nervous about their 401k balances and things like that. There seems to be some fear slipping into the stock market and to the market in general. Obviously, we've got a huge inflation issue, which is driving interest rates up, and causing some of the larger panic. But on the labor market side, the unemployment rate nationwide is very, very low. And we're sort of entering back into this place where we were pre-COVID, where, I was hearing from clients all the time that they just can't find workers. Um, and during COVID, for a while there, it seemed like at least part of the reason for that may have been some of these enhanced unemployment benefits that were available. And sort of a common refrain that I heard, and some of you probably heard as well, or maybe even experienced, was that people are making more money at home than they are working. And that's just not really the case anymore, but it's still difficult to find workers. And due to inflation, wages are increasing, but they're not increasing fast enough to keep up with inflation, which is really tricky for companies, I think, because that means that even though you may be raising wages for your workers, which is already a difficult thing to do from a financial standpoint, workers may still not be happy enough about that, because their buying power in the economy has decreased due to inflation and the cost of gas and groceries and things of that nature. And so there's a lot of competition out there for workers. And there's a lot of movement going on in the labor economy. You've probably heard me talk a little bit about, or have seen stories about the Great Resignation, or the Great Reshuffling, something like that, which is this idea that the pandemic sort of induced in the labor economy a sort of rethinking for many workers about what they wanted to do with their careers and their livelihoods, and it led to tons and tons of resignations, and people quitting and changing jobs. And it sort of started out with younger workers who were sort of in their first couple of years of employment, and now it's sort of been seen across the board with more experienced workers as well. And looking at some statistics, that's still happening at a pretty good clip. I'm not sure if y'all are seeing that within your own companies, but would be interested to hear about that in the chat. But that's certainly causing a lot of issues at the moment. And we'll talk a little bit more about this, but workers have sort of increased their bargaining power due to how difficult it is to find people, demands for wage increases, things like that. Yeah, we're still dealing with a lot of employees that are asking for or demanding remote work. A lot of employees worked remotely during the pandemic and figured out that, hey, this is pretty nice. I want to keep doing it. I don't think there's any reason I can't. So despite sort of these large calls back to the office, many employees are asking to remain at home, or working remotely from some other location. Some companies are still instituting the return to work policies, and they're maybe offering remote work as a benefit or something like that. Everybody's handling it a little bit differently. I know I've talked to some clients that have instituted a return to work and haven't seen issues with it, and I have other clients who've had a lot of issues with it. So I think it just kind of depends, but I think the remote work, which we'll talk about a little later, is certainly here to stay. It's going to continue to be an issue moving forward. So One thing that I'm seeing currently is a lot, as sort of a legal trend, is a lot of litigation over the employee movement. And obviously, if you've got a lot of employees quitting, you're going to have some employees may decide, hey, look, I've been, working as a waiter at this restaurant, and because of COVID, I'm decided I'm going to switch careers or something like that, and I'm going to quit, and I'm going to go back to school and do something else. But invariably, for the most part, especially with more experienced workers, if you've got a lot of people quitting, you are going to have a fair amount of people that are going to go work for a competitor within the industry. The statistics tell us that. And for most workers, they make business contacts, they learn how to do a certain job, and they're sort of not going to move outside of that industry. And so litigation over non-compete agreements, non-solicitation of employees, non-solicitation of clients, and non-disclosure agreements. Anecdotally, I've seen a big increase in that. I've been working in 2022 on a couple of really big cases concerning that have taken up a lot of my litigation time. And I've had a lot of clients, probably, induced by this, a lot of clients, coming to me asking, hey, do I need a non-compete with these employees? Would it do me good to have one? Just due to the turnover, and maybe thinking that it could potentially help reduce turnover. And so helping a lot of clients with that, I think that's a real hot button issue at the moment. I always say this when I talk about these so-called restrictive covenants. This is one area where I will, put a strong plug in for you to reach out to legal counsel, whether it's me or somebody else, to get these types of agreements drafted carefully. South Carolina courts, as a general matter, don't really like them, especially non-compete agreements. They don't, as sort of a matter of public policy, like to keep people out of work in his or her respective field. And so judges look at them very, very carefully and see how well they're drafted and how sort of narrowly tailored they're drafted to protect the business's interests. And so this is definitely not an area where you can sort of find something online or reach out to a friend who works at another company and copy and paste type of thing. This is something that if you want to have the agreement to have in any teeth to it, it really needs to be drafted by counsel. The other thing I would say about them is, I think it does matter. I think there's a good bit of strategic thinking that probably needs to happen in regards to which workers have these types of agreements in place. And I generally think about kind of, a couple of different things. Number one, you have your really sort of key employees, C-suite executives, key salespersons, things like that, if they were to quit and go work for a competitor, would cause potentially a lot of damage to the company. Those are the types of individuals that you probably want to consider having a non-compete agreement with. And then, there's probably a level below that where you may not feel the need to really have a non-compete. Like, yeah, it would be bad if this person left and worked for a competitor, but they're working for a competitor isn't really going to damage us that much. And maybe you want to just have a non-solicitation where they're not going to be calling on your clients for a period of time, or they're not going to be trying to convince their former coworkers to come with them and work somewhere else. And then, I generally like to see a confidentiality or a non-disclosure agreement with everyone in the organization that the employees sign when they're hired, in conjunction with their offer letter. And I do like to see that be a standalone document that is, not just a provision in the employee handbook that says that, the company protects confidential information and employees, agree not to disclose it to third parties. I'm talking about a separate contract that's a non-disclosure agreement that provides specific ability for the company to go to court and get certain things if an employee violates it. There are all kinds of legal things that need to be in there in order to make it valid. But I like to see those non-disclosure agreements with, signed by everyone in the organization, regardless of their level. All right, you can go to the next slide, Brittany. One other sort of trend that I'm seeing a lot coming out of COVID is, and this obviously has to do with remote work, is a trend of workers working for you, but in other states. So let's say that you're a Greenville-based company, and most of your workforce is located in the office in Greenville, but you have hired somebody who, let's just say you have an employee who used to live in Greenville and used to come to the office, and they have moved to Ohio to be closer to a family member during the pandemic, and they have decided they wanted to stay in Ohio and work for the company remotely. A lot of that is going on, or you may have clients or salespeople that are in different places, things like that, and those types of situations raise a lot of interesting legal issues that we've sort of been researching internally, and also have been talking with clients a good bit about. Just for example, a couple of things to think about if you're a Greenville-based South Carolina employer with a worker working from their home office in Ohio. Do you have to, as a company, register to do business in Ohio now that you're employing someone in that state, if you want to call it that? Do you have to register for a tax account with the Department of Revenue in Ohio? Do you have to register with the Unemployment Commission or the Labor Department in Ohio? What happens in employment contracts if you have one with choice of law? Do you have to, in South Carolina, do you have to withhold South Carolina state income tax from that employee's paycheck if they're working in Ohio and not working in South Carolina? What happens if that employee in Ohio is terminated and thinks that he or she has been discriminated against? Can they file a lawsuit in Ohio, or can they file an administrative claim with the Ohio Labor Department or Ohio OSHA or something like that? And all of a sudden you're subject to jurisdiction in Ohio, and you've got to, go fight a lawsuit in Ohio, hire an Ohio lawyer, those types of things. Those are all sort of things that you may or may not have thought about, what and need to be taken into consideration if you have an employee who is asking to work remotely from another state. I think it's, and sometimes if an employee wants to work remotely, you don't even know where exactly they are. Maybe somebody says, hey, I want to work remotely from my home office, and as far as their address and their personnel file says Greenville, South Carolina. You had no idea that they've been in Mexico since the pandemic has started, working from the beach. And so I think it's important to sort of think about when you get these requests for remote work, how you are going to having a process in place essentially to and an agreement ideally signed by the employee with sort of terms and conditions requiring them to let you know exactly where they're going to be working, where they plan to live, and notify the company of any changes there. Because that so that's going to be an interesting issue, and I think that this is another area where you just sort of have to cross that bridge if and when you come to it. One interesting thing, and I see that Stephanie has made a comment in the chat about this issue, and it was kind of my next topic. I think this issue of withholding taxes is particularly complicated. We've done some research internally here. My colleague Chris Gant Sorensen and one of our tax lawyers, Tyler Gillum, have been researching this over the last couple of weeks, trying to figure out sort of where the rules are and how they come into play. And I think that my colleague Tyler is going to be putting out a blog post in the coming weeks that will delve into this topic in a little bit more detail. But essentially the question is, okay, if you're a Greenville, South Carolina based employer, and you've got, an Ohio, somebody that's working from their home, they live in Ohio now, and they work in their living room in Ohio. What do you do about that? Do you have to pay? Does that person have to file a South Carolina income tax return? Do you have to withhold taxes on that? South Carolina income taxes. And there's a couple of, Brittany, if you go to the next slide, I have a couple of citations there. And Revenue Ruling 22-3 is in South Carolina, kind of the key document, I believe. And it may be worth looking that up. This is a South Carolina Department of revenue ruling on this issue that sort of provides the most clarity, although even as a lawyer, I don't feel like I understand it completely. And so, fair warning before you dive into that document. But the answer seems to be that if you have a non-resident employee, let's take this employee we've been talking about in Ohio, who does not ever come to South Carolina to do any work, then the answer is generally speaking, you would not have to withhold South Carolina income tax from that person's paycheck. They would not have to file a South Carolina tax return. You would, however, have to deal with Ohio's payroll tax laws. And that, each state is going to have its own rules about that. You may have to withhold Ohio, income taxes from that person's paycheck, and they certainly would have to, file an Ohio state income tax return. And you probably are going to have to register to do business in that state. Register with the Department of Revenue or, whomever does the taxes in that state. So that sort of situation seems to be rather straightforward. It gets a lot more complicated if the employee in Ohio comes to South Carolina, comes to the corporate office in Greenville to do work throughout the year. Basically, what we can tell from the revenue ruling is that the rule is that the South Carolina employer should withhold South Carolina payroll taxes on those services that are rendered in South Carolina. So that would mean if the Ohio employee sort of routinely comes to South Carolina, let's say twice a month for 2 days at a time to take meetings and stuff like that, theoretically you would have that those would be services rendered in South Carolina that would subject that person to South Carolina income tax. Unless it's a de minimis level of work. And so if that Ohio employee, comes to an annual board meeting or Christmas party in South Carolina or something like that and works a couple of days, that's probably not going to be a big deal. But I mean, you can see how very complicated this gets. And the point, and like I said, we're gonna have a blog post that's going to provide more detail on this. And I'm certainly don't hold myself out as an authority on this question. But I think the point is to highlight that it's a difficult issue that you need to be thinking about if you've got employees working in other states, particularly remotely in other states. All right. One other thing that you have probably been seeing in the news, you may or may not have been, that sort of started out as more of a big national story and has recently become localized a little bit, is some union activity. And South Carolina has traditionally had either the lowest or the second lowest rate of unionization in the country. So it's not really traditionally been a focus of my legal practice or of these presentations to talk about labor unions and issues with them. And across the board, across the country, for the most part, across different industries, the unionization rate has been declining really since the 1970s. With that being said, some of these large manufacturing corporations, for them, the Boeings of the world and things like that, for those organizations, the Volvos, those type of organizations in South Carolina, this is always, an issue that they have to think about and deal with. In the last couple of years, we have really seen some increased activity among service workers. So you may have seen news stories about workers at Amazon warehouses. There's been a couple of votes at Amazon's big facility in Alabama, the Bessemer facility, and now they've had 2 votes there that have rejected the union, although it's been pretty hotly contested. And then a facility in New York that actually voted to unionize at Amazon warehouse there. And then more recently, we've seen Starbucks locations, individual Starbucks locations vote to unionize. And these are just votes happening at that specific store, not baristas nationwide for Starbucks. Some of it is locally owned. Some of the stores are owned directly by Starbucks corporate. But we just had the Starbucks on Pelham Road in Greenville become the first Starbucks in South Carolina to vote to unionize. And I think this is probably getting 7th or 8th, maybe something like that. That I'm aware of, Starbucks that has voted that way. So it's starting to pick up steam. And I think there's a couple of other locations throughout South Carolina that will have a vote on this issue as well. And there's a specific union that's a sort of arm of the service workers union, which is sort of coordinating all of this. And essentially what happens, for those of you that aren't familiar with unions and collective bargaining, is that once the union vote is certified, the National Labor Relations Board is the regulatory body for that. Once the vote is certified, then the owner of the store, whether that be Starbucks corporate or an individual, franchisee owner, enters into a process of collectively bargaining with the union. And the collective bargaining agreement that's ultimately reached will determine things like what are the circumstances under which employees can be terminated, what are certain benefits of the employees, all of those types of things. It's very, very heavily regulated. Costly, and so that's one of the reasons that some organizations put up a fight against the unionization efforts. So that's kind of happening. It probably it's not something that you may ever have to deal with. It's still very uncommon for the most part in South Carolina. And across the country, really. And this new activity does seem to be very heavily focused on the Amazons and the Starbucks of the world, these sort of large, high profile, publicly traded corporations with, just tons and tons of employees. And so I've got no reason to panic there on the on the PowerPoint, but I think it is sort of good to be aware that this is going on and sort of be aware that it's an issue out there, because you may get questions from your employees. You may have somebody come into your office and say, why aren't we a union workplace? Have we ever had this type of thing? Like, what would I do if I were interested in that, or something like that? And so it's good to be aware of it and sort of know how it works generally, and sort of be on the lookout for that type of thing, and keep an eye out for worker discontent and signs of organizing. This is another one of those areas that the National Labor Relations Act is very strict about what you can and can't do as far as preventing employees from trying to unionize. Certain things you can say, can't say. So definitely reach out to counsel. If I've worked on drafting employee handbooks for any of you on the webinar, you probably have seen some disclaimers I've put in employee handbooks about the National Labor Relations Act, and it's very strict about what you can and can't do. So just keep that in mind. All right, so those are some trends that I'm seeing in my practice and in the news. As I said earlier, South Carolina General Assembly just wrapped up its legislative session, and it was the second session of the 124th General Assembly. So each year it's one part of a two-part session. So the bills that did not pass at the end of this session will have to sort of start over in the state legislative process. And I've got a couple of things up here that are sort of employment related, that high profile things that did not pass. We'll talk about a little bit about the pay equity legislation, and you've probably heard us talk about that before. The tax credit for employers for hiring individual, veterans or formerly incarcerated individuals did not pass either. And so that seems to have some support, and we'll be taking up again, but we won't go into detail on that. And then medical marijuana, I think a lot of you have probably been following. South Carolina is one of the few states that does not have at least a medicinal marijuana law. And each year it seems to gather a little bit more steam, and it was starting to look like in the spring that maybe it could pass this session. It ultimately did not, due to a little bit of I wouldn't call it a formality, but a little bit of an issue unrelated to the actual substance of whether or not we should have a medical marijuana law, which was sort of a state constitutional tax issue on cannabis sales. And that's what held it up. And so, probably good to just talk a little bit about that bill, because I think it will be coming soon. I've been saying that for 5 or 6 years now, and one of these days it will become law in South Carolina, I think. This is important to keep in mind with remote workers, obviously, too. One of the things I mentioned about Ohio employee is, what if Ohio has, I'm not sure off the top of my head, what if Ohio has a state marijuana law, that has legalized marijuana and has anti-discrimination or accommodation provisions in that law? What are your rules for drug testing that employee or terminating that employee if you need to? And so this is the South Carolina Compassionate Care Act, the one that's being considered in the General Assembly. It did pass the Senate, which apparently is a little bit of the easier hurdle, actually, in this General Assembly. But it was defeated in the House due to that constitutional tax issue I mentioned. And this is a pretty limited bill. It does permit very limited medicinal use for, under a doctor's prescription for, very specific medicinal reasons. Although, typically, a lot of times these bills are sort of the first step into broader legalization. But this specific Compassionate Care Act for employers does not have a private right of action for an employee to sue a company because they were fired over a marijuana issue, and no requirement to accommodate in your policies marijuana use. Either use, on site, possession on site, or even in the event that somebody may not be impaired in the workplace, but tests positive. There's sort of those type of rights are not given to cardholders under this bill. And so it's not something that is probably going to have a lot of immediate litigation in South Carolina once it passes, although as you all probably know and have experienced, use of marijuana is more and more common. So it does put employers in the position of having to figure out how you want to apply your drug testing policies in this environment. But we'll have to wait and see. It's one of those that, of course, we'll keep you posted on, and we'll cross that bridge when we come to it. One of the things that did pass this legislative session was House Bill 3126, which is the COVID vaccine ban. There were a lot of different COVID vaccine bills out there since the start of the pandemic. This bill was signed by the governor on April 25th. And essentially what it does is it bars the state of South Carolina, local governments and school districts from mandating the vaccine as a condition of employment. This is one of those bills that, I know the COVID cases are going back up again, but this is one of those bills that I'm hoping will have relatively little significance on a go forward basis. Got my fingers crossed on that, but it has been passed. It has become law. And if you work for one of those, if you work for the state subdivision or a school district, then you, under this law, it is illegal to have one of those policies. It also bars the state from terminating a first responder who chooses not to be vaccinated. And then for private employers, the one thing it does is that it makes individuals who are suspended or terminated by their private employer for refusing to get the vaccine eligible for unemployment benefits. Again, not sure if that is going to affect any of you or many of you on a go forward basis, but it is important to know that. I've got a copy here of the bill, and there are, a couple of interesting things in here, I think. One is section 1, the General Assembly declares the practice of discrimination against an individual because the individual has chosen not to receive the vaccine as a matter of state concern, in conflict with the ideals of South Carolina and the nation, and the discrimination interferes with opportunities of the individual to receive employment and develop according to the individual's own ability. So, that's a pretty clear policy statement about what the state of South Carolina thinks about instituting a policy like this. And so I don't know if any of you on the webinar, if any of your organizations still have a mandatory vaccination policy. Although this law wouldn't apply directly to you if you're a private employer, I think that policy statement is definitely something to keep in mind if you're trying to decide whether or not to keep it. Let's see here. I've got a couple on the PowerPoint. I have a couple of other provisions of the bill. You can see those on the slide. States that a federal vaccine mandate is unconstitutional. I think that's a political statement more than anything. It does state that a religious exemption or a medical exemption must be honored in regards to any COVID-19 vaccine requirement. So, and they say a medical exemption may include the presence of antibodies, a prior positive COVID test, or pregnancy. So, that, I don't know what to say about that. That's certainly interesting. I think a lot of my clients who instituted a mandatory policy were pretty liberal with their consideration of requests for accommodations, if for no other reason than they didn't want to get involved in litigation over whether or not somebody's medical accommodation request was valid or not, unless it was just sort of clearly on its face bogus. But you now see that in the law there as well. So one other item that did pass was the so-called sub-minimum wage. So this was Senate Bill 533. And I'm not sure how many of you were familiar with this, but under the Federal Fair Labor Standards Act, there's something called the 14C Federal Waiver Program, which allows employers to seek a certificate from the U.S. Department of Labor, which would allow their company to pay certain workers, for purposes of this, workers with disabilities, certain workers with disabilities less than the federal minimum wage of $7.25 an hour. And that probably seems insane to a lot of people. The idea behind it was that, as a way to actually encourage the employment of individuals with disabilities. And you could sort of debate, I think, the policy implications of a rule like that, but that 14C federal waiver program under the Fair Labor Standards Act still does exist. So that has not been reversed by Congress. Many states have passed laws to say that companies within their state cannot utilize that program to pay below the minimum wage. So effectively, it's a state minimum wage that you can't take advantage of this exception. I read some news articles where, and I'm not sure where they're getting this information, I guess from the U.S. Department of Labor, Bureau of Labor Statistics, based on certificates, but it was estimated that about 3,000 workers in South Carolina were being paid under the sub minimum wage under this provision. So it may have some impact moving forward. And that this is going to be phased in. And so employers have until August 1, 2024 to actually institute that change and raise those employees up to 725. I'm not going to go into pay equity too much because we've talked about it at webinars before, but for those of you who have not been following along, South Carolina has some pending legislation that would address pay equity and specifically the gender pay gap. And there's pending legislation at the federal level as well, although it's probably actually more likely to pass in South Carolina. And it basically ensures that jobs that require comparable skill, effort, and responsibility should be paid the same. If there's any difference in pay, it should be based on a business factor, which is just a slight change from the current pay equity laws. And then it adds protections for employees and job applicants so that employers cannot ask about your wage history in order to sort of perpetuate the pay gap. And it also increases transparency in that process of recruitment and provides that employers have to give wage ranges for each position to job applicants and update that for current employees on a regular basis. I've kind of been thinking that this one was going to pass in South Carolina. I can't remember exactly off the top of my head where it stalled in the General Assembly, but it did not pass this session. So this is another one that we'll have to keep our eyes on and see what happens with it. There's some more information on the slides if you want to read a little bit more about that bill. So a couple of other updates before we go more at the federal level. As many of you may know, much of what happens at the federal level with employment law these days is at the administrative level. Congress is not really doing much on the employment law side or any side for that matter. And so this is mostly administrative level. I put up the EOC every year updates their priorities for what they're focusing on for discrimination. And nothing really earth shattering here. I did want to include it just so you know. You see the pay discrimination and pay gaps. That's been a focus for a number of years now and continues to be. And the other thing that I want to point out, which is again not new this year, but is combating gender, transgender, and sexual orientation discrimination. I do see a big increase in litigation over this and questions from clients about it. It seems to be an area where employers can easily slip up as far as things like use of pronouns in the workplace and certain policies that apply to different groups of people that are sort of unintentional discrimination. We had Palmetto Sherman Charleston had a whole day seminar on LGBTQ issues, and I gave a presentation on some of the issues, discrimination issues with that. it was a great kind of one-day conference, and there's a lot of things to consider for your workplace there, but just know that that is a priority for the EEOC and something worth thinking about. One interesting thing that I'm not going to spend much time on, but is worth noting, is that the Department of Justice and the EEOC basically sent out a news report that cautioned employers to be careful about the use of artificial intelligence in the workplace with respect to human resource issues. And, when you hear about artificial intelligence, you think about, robots in the workplace or something like that in manufacturing. But this is really talking about more about the use of software, and sort of these advanced programs to screen applicants for employment, monitor employee productivity for performance evaluations and decisions on termination and promotion and things like that. We're seeing more and more use of artificial intelligence. I think recruiting is the really big area where it's being used, but you're seeing it used for performance monitoring, particularly with respect to employees that are working remotely. So since you can't walk down the hall and see how hard they're working, you can install software on the computer that determines how often the person's typing on the keyboard or something like that. And the report just basically cautions employers, look, you can't sort of blindly trust artificial intelligence software that tells you that employee B only worked 6 hours today, they should have been working 8. And the primary reason for that, I mean, they point out the Americans with Disabilities Act, in the, if you blindly trust this and fire somebody over it, have you considered whether or not that person can perform their job with a reasonable accommodation? Sometimes you've got to step in and sort of make those type of human decisions and not just trust the machine learning. So that's something to keep an eye on if your organization is using or thinking about using that. So I saw a question in the chat about this from Paul, that he keeps hearing rumors about the Department of Labor raising the salary threshold for overtime. That is apparently coming down from the Department of Labor. And the thought is the current threshold for the salary test, which is just one of 2 tests to determine if an employee is exempt from minimum wage and overtime requirements. The current salary test is $684 per week, which is roughly $35,000 per year. You may remember that in 2016, President Obama's Department of Labor tried to raise that to $47,000 roughly per year, but that was blocked by a federal court. And the reasons for that federal court decision were a little bit convoluted, but the Department of Labor certainly feels like they can try that again and make some adjustments. But this does seem to be, from everything that's coming out of the White House, that seems to be a priority from President Biden. He's pushing the Department of Labor to do this. And the news I'm hearing is that they're going to go back try to go back to at least that $47,000 level, if not even higher. And you're probably thinking, well, if the federal court struck that down, how could they do that? Well, it wasn't just the number. It said the Department of Labor sort of focused too much on that and not on the duties test. And so obviously lawyers at the Department of Labor think that they can go back with a new test that will pass constitutional scrutiny. So we'll see what happens with that. No reason to plan on anything yet. We just have to to wait and see what the Department of Labor does. And the National Labor Relations Board is planning to issue a revised standard for determining whether two entities are joint employers. It said in February of 2022. I did not check before we came on today to see if that has actually come down, but I can check on that. I don't know if you all have been following joint employment, but joint employment is one of those things that does the standards seem to change by the administration and by the Department of Labor and the National Labor Relations Board. And so that's something to keep an eye on as well. And I think that as we got a couple of minutes here, I think that's all I had on the PowerPoint. We're almost at an hour. Yeah, you can see my contact information there. If you need to reach me, I'm going to open the chat real quick and see if there are any questions that I can answer here. So it looks like Stephanie indicated they've had an issue with a work from home employee who works in another state, and it was a nightmare. Yeah, I think that illustrates the point beautifully. I think it sort of is a nightmare, and it's a little bit different in every state. So it's going to create problems if you've got employees all over. And then Jason asks, is it still accurate that if you have a worker producing work in a non-state income tax state, then the income tax comes back to South Carolina where the company is based? I don't know that, Jason, off the top of my head. I'd have to check with one of our tax lawyers on that. So there are certain states, he mentions Tennessee, Florida, and Texas. I knew that Florida and Texas were like that. They have no state income tax. And so the question is, would that income then be reported in South Carolina? I'd be speaking way out of turn here, but I would think that the rule still applies that I talked about earlier, where it depends if they have a connection to South Carolina, but I'm just not sure. I'd have to check with our tax lawyer on that. And it looks like, I think that's everything. So it is 2 minutes to 1. Thanks everybody for joining today. I hope you found some of that informative. I've got my contact information there if you need to reach out to me or to one of my colleagues, and hope to see some of you in person soon.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.